Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, and welcome to another episode of I Now Pronounce You Divorced. I am Dan Cuneo, and today we are joined by Stephen Lukacs, an attorney at Melone Hatley. Stephen, thanks for joining us.
Hey, good to be here.
In one of our prior podcasts, we were talking about managing client expectations, and that just isn't involving as far as what they want out of the case, or if you get a bad ruling, or when had you on the Business Blueprint talk about collections. Managing client expectations also is advising the client who your judge is, or even taking it a step further, who the opposing party is, meaning the attorney, because that will weigh in as far as strategy and possible outcomes. So if you don't mind, can you walk us through what that looks like? And for those who are potential clients tuning in or new attorneys listening, how important is it, the judge that's assigned to the case?
It's everything I'm about to say is going to be slanderous towards judges, but I promise you it came from former judges. This is things that I've been told by them that I can confirm I've seen. And one of my favorite ones is a retired judge said, judges are not stupid, but they are very lazy. And what he meant by that was not that they're going to not pay attention to your case. They're going to take an easy answer. And that makes perfect sense, right? I mean, if you've ever looked up Occam's razor, the simplest path to the solution, or the simplest explanation that requires the least amount of externalities to be taken into account is generally the correct answer. So one of the things I like to do is give the false dichotomy of choice to judges, where no matter what they rule, it's what I want them to rule. And I kind of stole this from Business Principles. If you've ever seen, I don't know if Colgate and Crest are the same company, but if two toothpastes are owned by the same parent company, people don't care even if they know that. They will still like the idea that they have the choice between the toothpastes, even though they're the same thing and they're going to the same place. It does not affect it at all. So, for example, like if we have a show cause as to why we shouldn't hold you in contempt of court, you violated a court order. Oftentimes, judges don't want to rule on this because it's very difficult to tell someone they're going to get fined or put in jail. That's a difficult decision for a judge to make. Mm-hmm. Well, I give them the false dichotomy of choice. Because the other attorney, if they know the violation's there, they have to argue ignorance. My client didn't know that they were violating, and pray that the court says, well, this is a court of equity, not a court of law, and we'll forgive it. Well, ignorance or malice, Your Honor. False dichotomy, which I don't say false dichotomy, but either if someone doesn't do a job correctly, it's either they didn't know how to do it or they deliberately didn't do it. When I was a kid, I used to mow my dad's lawn. I didn't know how to do it at first, and I used to jam the mower because I was going over too much grass. Eventually, Dad comes out, fixes the mower for me. Great. Then I learned eventually I could run over the grass purposefully and jam the mower. And then Dad would come out, fix it, and do the lawn for me. So whether it was ignorance, I didn't know how to mow the lawn, or malice, I'm deliberately screwing up the job, doesn't matter, Your Honor. The order was violated. So I leave it to the court to decide whether Mr. So-and-so was ignorant or malicious, but the ruling is still the same. Now I've given the judge an easy out. They don't have to say you were maliciously violating this order, I'm sending you to jail. They can say, I find that you ignorantly violated it and I'm still punishing you. Easy outs.
And in those situations, I'm thinking in the states that I'm licensed in, when we're trying to prove whether someone violated something, it's, was there a court order? Was it valid? Did they have the ability to comply with it? And did they willfully not comply with it? So when you're talking ignorance and malice, is there a time when maybe when you're giving the court those options, which I think is a great strategy, that you're maybe leaning a little bit more towards one or the other?
Yeah, well, it depends on the situation. Generally, with anything custody related, I say this to all my clients, I'm the child who went through divorce. I promise you one thing, no matter what is going on in your divorce, the kids are hurting. Doesn't matter who did it. So the more malicious, angry, resentful we make this, that is coming back on your kids at some point. So if it's a violation of custody, I make sure to lean towards the ignorance part, right? Or I won't say malice. I'll say there's a lot of resentment in this case right now. And I don't care what that resentment manifested in. other than a violation of the order. So the court, again, can make the decision about what happened here, but we know someone denied visitation. We got to do something about it. If it's property, okay, lean into the malice. No kid divorce. There's a lot of money involved. You absolutely want to lean that direction. And again, it depends on the evidence. If I know someone just was a complete doofus and violated the order by accident, I don't sit there and lie. I don't manipulate the facts. You tell a story, but your story is still based on what happened from someone's perspective. That doesn't mean fabricate a tale. It means tell the story.
And you raised two interesting points. One is if it's property, you're going to lean one way. If it's custody, you're going to lean another way. And at the end of the day, at least in the states that I'm licensed in, no matter what the actions are, the court has to look at what is in the best interest of the child or the children. And so whether it's malice or ignorance, how does that affect the kids? And that's such an important point that gets overlooked a lot. And especially when I see the other side arguing, they're trying to shame my client. Well, let's more focus on the kids. And in your experience, do you see that a lot? And if so, how do you handle those situations?
That is one of the best questions someone's asked me. Yeah, I have had situations where there is an absolute stone cold, easy case violation of an order, but the best interest of the children certainly should be in play. This puts judges in a weird spot because technically the violation of the order is something by statute, and therefore by the letter of the law, what that person did is not in the best interest of the children. But let me give an example. What if you have a situation where the child is completely alienated from one parent by the child and the other parent's own actions? The parent violating, not giving custody over because, the other side hasn't seen the child in 7 years, and that was the other party who did that. Okay, well, maybe the one party is technically violating the order, but in that exact situation, the judge didn't even rule on it. Said best interest of the child is the child stays with who they've been with for 7 years. So those weird situations, always keep best interest of the child in mind. Do not try to go, I am this person and I've had to adjust to it. If you go letter of the law, especially in Virginia Beach, well, good luck. You got to tell a story. That's what we're here to do. Tell a story.
That is a great segue into a topic that I clearly believe is overlooked by a lot of attorneys. And I just, going back to my litigation days, is I would always talk to a client, okay, what is our story? What is the theme? And stick to it. How important is that in your practice?
The story is everything. I'm a huge film fan. That's what I do in my spare time. I play video games that look like film and I watch film. And this sounds incredibly silly, but if you're an attorney out there struggling to put together a story for your cases, I actually encourage you to go watch Quentin Tarantino. And I mean, watch it, not the crazy over the top gore and stuff that's in his movies and stuff. Watch the dialogue. Watch how people talk. He will always leave you asking questions. And that's what I do in my opening arguments. If you want to set up a story, it's devastating if you can pull this off. You leave your final question to the judge. Question, not statement about what you're going to prove. You have to ask yourself X, Y, and Z, judge. Why did mom file this false protective order on January 6th? And when you hear the evidence, that will be answered for you. And immediately, every time I do something like that, the judge's head pops up and goes, oh, you've laid that foundation. You've piqued their interest. And that's way better than just rolling through the statute. It just is. Like I said, tell a story. I wish it were different. I'm a letter of the law kind of person, but telling a good story within the confines of the law always beats the technical argument every time.
I agree. The law is there more of a guidance to help us and looking at the statutes, but it's the story, it's the theme, and that's what keeps the judges engaged. I remember litigating, and to what you just showed was the judge's head was down because he or she just lost interest. And in my experience as well, I've always seen just attorneys parade a ton of witnesses in or just throw everything against the wall and hoping something sticks. I am of the opinion that less is more. What are your thoughts?
I won't say I'm giving out too many secrets here, but I keep things as quick, short, and simple for anything but a final divorce trial as I can. I don't like bringing a lot of extra witnesses. It's just someone to cross-examine. But most of the time, you got to remember, even if you believe in your case and your client believes in their case, the reason we're going to court is because there's a disagreement here. There's always something you're not going to see. There's always some angle of their story that's going to come into yours, and you go, okay, maybe that's a good point. So I never give anyone opportunities to redress. I get up and tell a simple, quick story. If I can get it down to one witness, the client, and maybe one backup witness, that's what I'll do. And even then, I'll build my case off the other side's discovery so I can streamline my discovery. I don't have to lay any foundations. They say, well, where is this from? It's from their discovery, Your Honor. Let's move on. It's their evidence. let's do this quickly. And it's I've done this to a lot of people in town, and I know that they're angry about it because I put on 30 minutes, they put on 3 hours, and somehow I win. And they're like, how? Like, because I told the judge made his mind up when I finished after 30 minutes, man. Yeah.
Yep. No, you're absolutely right. I remember doing seminars. We would call them divorce camp or divorce school, and we'd have about 100 plus people come in, and I would always present and give that same analogy. A lot of times judges' minds are made up. So you got to keep them engaged. Otherwise, they're just going to do something else. How do you advise a client that's this strategy? Because clients come in and, they see on television or movies all this excitement and drama that goes on in court. And in my experience, it really hasn't been that much drama. And so I think it's sometimes maybe a little bit disappointing to the client. How do you advise the client that, okay, I'm going to go in with less is more, and let the client really truly believe in what that strategy is?
Okay, so managing expectations and radical transparency. I watch those judges and I tell them that's what I'm going to do from day one. Whenever we're in court, I'm going to have a flow chart. But any piece of this, it's not a Jenga puzzle where I pull one out and the whole thing collapses. I'm going to structure this so that I can pull out anything that's not relevant on the fly. And I don't encourage new attorneys to do this. Read the judge. Your eyes should never come off that judge, because if they're not paying attention, move on. Move on. You're wasting their time, in their opinion. They won't tell you that. But the second you see the judge scribbling something down, looking up, making eye contact, I've even had times where I have deliberately not drawn out evidence because I saw the judge perk up and knew the judge was going to ask the question. I see the judge almost open their mouth like they were going to say it. And I go, oh, mark that down. Let the judge ask that question. Mm-hmm. I'll get it on cross or something, or I'll recall my witness if it doesn't come out. But just keep reading the judge. Tell the client that too, because then they'll notice it. Tell them what you're looking for. When you see that judge's head perk up, you go on a story right now. And we have a narrative built into every one of our questions. Ask generic questions, don't lead your client. No. Have them tell their story, and they say, when that judge perks up, you go on your full narrative. Until that judge's head goes back down, you keep talking.
Mm-hmm. And you raise a point as far as prepping the client. Well, if you don't mind, walk us through what that preparation looks like when you're getting ready to go into a trial. Because what I'm thinking is, from how I prepared clients was, when you hear me object, you stop talking and then let me finish the objection. Or when someone asks you what is the time, you just give you answer the question only, or what is the day? Today is, Monday, or whatever day it is, right? You don't say it's Monday and then the month and then the year. It's just ask the question only.
Okay, so the prep goes entirely, for me at least, it's based on who opposing party is, or opposing counsel is, sorry. If it's a counsel, people always hate it when your attorneys get along with each other. That is the best thing for you. You will save so much money if your attorneys agree. If I know it's someone who's quick, short, sweet, to the point like me, our prep is pretty minimal. Let's go tell our story versus their story. If I know it's someone really long-winded, I sometimes let my clients get grilled, because if they are getting grilled for an hour on cross after we put up a half hour, do you have any idea what a bully that attorney looks like? I have seen them do this time and time again. I don't know where people learned this. This must be some 90s or 2000 strategy where you're just going to go hard in the paint on cross-examination. Why? All it does is backfire. It makes you look like a bully. You're beating up on some housewife and grilling her about her sexual activities at night on very flimsy evidence, and it doesn't work. So again, my preparation, back to the question, is tell the story. If your story is simple, there shouldn't be a whole lot of prep. And guess what? We've talked, because we stay in contact with our clients very regularly all throughout this case. I have a binder already set up because we went to a JSC, right? If we're going to a final trial, everything's done. We know all the facts. We know our story. We stick to it, keep it like a casual conversation. So really my prep is for final trial is, several hours of making sure I got all the evidence, but I generally only take about an hour to go over testimony because I want my client to tell the truth. I don't want them to be loaded with a legalese answer. As long as they know their story, excellent. Now, if they don't know their story, okay, we're sitting down for 3 hours and going through this. But generally speaking, I'd say 9 out of 10 of my clients, I ask them the questions, they know their story, and we're good to go.
And that's great trial prep, or just even prep for any hearing, making sure that the client knows the questions that may be asked, but also getting them comfortable with the questions being proposed. I would always, if we had a mock courtroom, use that, or I bring in my paralegal and have him or her either be the other side and just go back and forth on direct and cross, and let the client get experiences of what does that look like, when to answer, when not to answer. It's developing that comfort so they're not nervous, and then they kind of have that run of the mouth, right, where they just keep talking and talking because they're nervous.
Yeah, I said film. Go. It's a silly movie, but it's, what is it? Al Pacino, Devil's Advocate. Go watch Keanu Reeves prepping his client for cross-examination. That's actually one of the more real things I've seen in film with cross-examination, where Keanu is asking very difficult, salacious questions to his client just to kind of throw her off. And yeah, we do that kind of prep. But again, I don't like doing it for 2 hours of cross on your own client. It's like you're giving them anxiety, right? They already go through the problem. Now they're going to get anxious about the 2 hours of grilling you did. You're putting them through the trauma twice. Get them prepped during the case. And then when you're at final trial, you don't have a whole lot of prep to do. You've already done it.
And that goes to radical transparency and client management and making sure that they know exactly what's going on. Because the worst thing is, going back to your comment about anxiety, is not knowing what's going on in your case. And that's always the number one complaint, whether it's from a bar complaint, looking from the ABA, rules of ethics, or just internally or externally. It's I have no idea what's going on in my case. And we may communicate, or we may think we communicate the best way, but it's always, how is the client perceiving it? And you've made excellent points as far as the best ways to communicate. I don't think we can ever really over communicate, because that along the way, and I love this tip that you were giving, the communication is the prep, right?
Yes. You should know everything about that case. If you're talking once every 2 weeks is low, but if you're talking for a half hour once every 2 weeks, I would be very surprised if your attorney does not know what they're doing by the time you are at final trial.
In your experience, when you're in the hearing or the trial, depending upon if you can take it up for some type of interlocutory appeal, are you also in your mind thinking, okay, if the ruling doesn't go the way that I want, how can I set this up for appeal?
I actually don't. I'm not interested in appeals. With JDR, it's different. Okay, so maybe with the JDR courts, you can appeal up to circuit court. It's de novo. It's a brand new case. I think that's a defeatist mentality. I don't want to set anything up for appeal. I want to win it right here, right now. And oftentimes that's, if you think that you're going to get someone tripped up on appeal, like, I don't know, maybe you have a judge who really hates spousal support and you know he's not going to issue it. Trying to get that to a point where it's appealable at a circuit court, you're trying to force an error out of the judge. Be like in baseball and saying, well, I'm going to hit the ball in such a way that it's going to force an error from the defense. No, it's an unforced error for a reason. They've got to make the mistake. So I don't like setting things up for appeal. I want to win it here, now. I've done my prep up to this point. Why should I be worried about an appeal? Let's get it done here.
Very, very good advice. I appreciate you taking time to speak with us today. For those of you listening, hopefully you found this information informative and valuable. If so, please like and subscribe. Again, this is Dan Cunha with I Now Pronounce You Divorced. Thank you.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.